Hi, I'm Mark Tensmeyer, and you're listening to Gospel Tangents.
It's the best source for Mormon history, science, and theology. I'm Rick Bennett. In a conversation I had with attorney Denver Snuffer, he said that if we throw out all the polygamy evidence after Joseph Smith died on June 27, 1844, there isn't much evidence. While I'm sure that's an appealing tactic of a defense attorney, would a judge allow that? So we're going to have another attorney, Mark Tensmeyer, talk about the law and types of evidence and things like that in our next conversation. And so it's going to be a fun conversation. You won't want to miss it. Check it out.
Welcome to Gospel Tangents. I'm excited to have a person who's certified in law to talk about rules of evidence. So could you go ahead and tell us who you are and where you're calling from?
So I'm Mark Tensmeyer. I'm calling from San Antonio, Texas.
And you are a lawyer by trade.
I am, yes.
And so you have a good grasp of law. Now, I know Denver Snuffer is a lawyer as well. And so we kind of have a little bit of a difference of opinion on whether Joseph was a monogamous or a polygamist. And so I'm excited to have Mark on here. We're going to try to settle that and talk about some of the common arguments of the Joseph was a monogamous crowd. And I'm not going to claim to be unbiased on this, but I am going to try to be as fair as possible. So, and I think you are going to do the same thing, right, Mark?
Right. I mean, I don't think anybody who approaches this is really unbiased, even if they might think they are. I think very few people, if anybody, is truly unbiased. But I mean, I like to think that people can come to conclusions based on evidence, regardless of whatever their personal bias might be. So, I mean, I have that much faith in the human intellect.
All right. Well, good. Well, one of the things I'd like to start off with, especially given your law background, is let's talk a little bit about rules of evidence. I know in my previous interview, and I know there are a lot of people that love to email me and say, hey, you've never talked to somebody who believes Joseph was a monogamist, which number one is not true. I've talked to Denver.
Yeah, you did.
Talked to Jim Van Cannon. And so if you haven't seen those, go watch them and you can hear their arguments firsthand. And I gave them a fair hearing. But I know in Denver's case, and I want to talk about him because he's a lawyer just like you, Mark.
Right. Yeah.
And one of the things that Denver said that I'd really like to question you on is Denver went to Michael Quinn and said, well, if we cut out all the evidence after Joseph Smith died, June 27, 1844, then there's not very much evidence that Joseph Smith was a polygamist, which personally, I think if I was a defense lawyer, that's exactly what I would do. I'd try to throw out as much evidence, especially
of course,
bad evidence that wasn't helping me as possible. And so, so I think it's a great defense tactic. I don't know that a judge would necessarily buy that. So can you tell us about that?
Yeah, well, I can speak to that. So first off, the rules of like the legal rules of evidence ought to be seen as in the context of a legal case. I mean, they don't necessarily apply to weighing and balancing evidence like in history or in any other situation in real life. And the law gives us a lot. We have laws that govern what kind of evidence can be considered, but the law doesn't give us a lot of direction on how to weigh and balance evidence, what kind of weight to give evidence. And so Denver Snuffer, he said that we ought to just cut off all evidence after Joseph Smith died. And I watched that interview, and he said you need to cut that off because cut it off there because you can't use evidence of what a dead man said after he's dead. And so in the law, there's the hearsay evidence about how anything that was said outside of a courtroom setting is hearsay. but that applies to all oral communications. So since Joseph Smith is dead, everything he ever said or did pretty much is based on hearsay. So even Joseph Smith's denials that he was polygamist is based on hearsay.
Yeah.
I mean, it's hearsay.
Important point there.
Right. Well, because I mean, a lot of people. Well, I mean, this is really the core argument. Is they say, well, we need to have something that comes directly from Joseph. We need to have his thoughts on this, not what somebody else thought about him doing. That's one of the major points. And but what does that even mean? I mean, he's not here to tell us. So everything he said is hearsay. I mean, when you say, well, we have this from Joseph, these articles in the Times and Seasons. So we have newspaper articles that quote him, and I think we can be very confident that he actually said those things. But then there's other things too we can look at. I mean, to try to get at what he did. And so I watched an interview in Denver Snuffer alluded to. I think he alluded to. He said you can't get it from the dead man. I think he might be talking about the dead man statute, which a few states have. And in every case, it's in most cases it's very, very restricted. So here in Texas, where I'm licensed, it only applies in intestacy cases where you're talking about something that the decedent said to a beneficiary about a will or something like that, something of that nature. That's really the only place where that applies in Texas. There's the hearsay laws, but then there's all kinds of exceptions to the hearsay laws. And, one of the exceptions to the hearsay laws a lot of states have is the ancient documents law. So any document that's over 20 years old is admissible. It wasn't something that was done. And so that would qualify for most any document we have, as long as it's found in a place where the document, there's a reasonable chain of custody there between where it's found and whoever said it. I mean, that's a lot of states have that, the ancient documents rule. So no, I don't think even using legal things, you could just cut off the rules at Joseph's death. And even if you did, there's still plenty there. So
I just want to point out that in any murder case, the evidence is collected after the crime happened, right? And so I think it's kind of crazy argument to say,
well, in any intestacy case,
yeah,
in any inheritance case, so in any probate case, where people are arguing who should be getting what from this person who's dead, there's gonna all the evidence.
All that evidence is going to be collected after the death. So
So there's always going to be a lot. I mean, it's yeah. So right. So this kind of goes to the idea. In these discussions, it's very, very easy. I use the term polygamy skeptics because it's a neutral term. I don't like to say polygamy denier or conspiracy theorist or that sort of thing, because I don't like to be dismissive. Whereas I obviously disagree with these people about how reasonable this outcome is objectively. I do understand that there are aspects of this that your average person would find compelling. Your average person, if you went out there and showed them a lot of the arguments that Richard or Pamela Price or Denver Snuffer or it's in the Joseph Smith monogamy paper, that they would find compelling. That I don't blame people for thinking that Joseph Smith was a monogamist. That said, I don't think that objectively it holds up. But I mean, the reason that I don't think that it's that I think that it's very reasonable that it's reasonable that people should think that should feel that is because polygamy is Joseph Smith's polygamy and non-group polygamy is a very unusual situation. You have activity, but non-group polygamy starts in, of course, there is.
Before you go there,
yeah.
I want to talk about hearsay. What's considered hearsay? Because I know that's a great way to dismiss
yeah. So if you want to talk
arguments.
about some of those things, yeah. So I mean, hearsay is anything you heard somebody else say. I mean, like that. So if it's used in the in the legal sense, it's anything that's said outside of the courtroom. anything said outside of the courtroom where the issue is being adjudicated. But when you usually say hearsay, it means anything that you heard somebody else say. So like say for example, when Lorenzo Snow says, I talked to Joseph, he said he took my sister, Eliza R. Snow, as a wife. I mean, that's hearsay because he didn't actually see that. He doesn't know. I mean, he only knows because it was told him by Joseph. Now that might still be something you want to consider, but technically that would be hearsay. But if you have any
But
of
it could
the
be admissible in court, though, right?
oh
If he's
yeah,
breaking
yeah,
a Polygamy
well
statute
yeah.
or
I mean,
something.
Lorenzo Snow did testify to that in a deposition, which in the Temple Lot case, that all the evidence was taken by deposition. So he did testify to that, and I believe it was objected to. I mean, it's all done by deposition, but yeah.
Was the
So,
objection sustained?
oh, there's no judge there. It's deposition, and so how it works with the deposition is you have the lawyers from both sides there. They question the witness. If the witness says something that the other lawyer doesn't like, they say objection this, and then it's up to the judge whether or not to keep that in the record. It really only matters if it's going to be a jury that reviews it, and so the judge can take that out so the jury doesn't see it. But I mean, if the judge is going to decide it, which was the case in the Temple Lot case, then I mean they're going to see it anyway. It doesn't really matter. But the theory there is the judge knows the rules of evidence, knows what to consider and what not to.
So
Whereas
if it were a live case where we were trying to decide if somebody committed adultery, which is against the law, or bigamy, which is against the law, and Wilford said that, would that be admissible in court?
Or Lorenzo, yeah, it would be. It would be.
I said the wrong Snow.
Well, yeah. So, well, yeah, I think it would be because there's hearsay and then there's exceptions to that. I think it would be because that would be illegal. I mean, it may or may not have been. It was arguably illegal, but it might have been. It might have been. But let's say somebody like Joseph Bates Noble, who testified in the Temple Lot case, who facilitated a plural marriage. He performed the ceremony. He approached Joseph. He said Joseph approached him about whether he would arrange for him to take his sister. He would take Joseph Bates Noble's sister-in-law, Louisa Beeman, as a plural wife, and so he did. He arranged that. He performed the ceremony. He testified too that he knows that they roomed together that night. He saw them go there, and they came out the next morning. So I mean, that's not hearsay. The parts about Joseph maybe approaching him, talking to him, maybe, but the parts about him performing a ceremony, absolutely not. I mean, you had in the Temple Lot case, you had 3 women who testified that they had been plural wives with them, and one of them really didn't want to answer the question, understandably, but the other 2 said positively that they had marital relations with him. That's not hearsay. So I think when a lot of the conversations I hear when people say, well, it's hearsay, I think what they really mean is we're not getting it from Joseph directly. And that's not hearsay. If that was the definition of hearsay, then the only person who would testify in any case, in any criminal case, would be the defendant.
Yeah.
If anybody,
obviously going to deny anything, right? You could never get a conviction if you had to rely on confessions.
Right. Right. And, and there are places in the world where that's basically how the criminal justice system works, but I don't think it's a great idea. And so the idea there is either they confess or you have to get like hard forensic type evidence. And so, and again, that goes to the really some of the core issues with this and why people think this is because what people like a lot. I put out a few informal surveys among people who are skeptical that Joseph Smith was a polygamist, and I've asked a number, and the most consistent response I got back on any question about anything was people said that there needed to be hard physical evidence that Joseph Smith was a polygamist before we could believe that he was. And I'm not really
as a child, right?
Yeah, and of course the thing is if we had DNA evidence of a child, and so in the absence of that kind of thing, what we're left to is we have testimonial evidence, and there's conflicting testimonial evidence, right? I mean, you have all those newspaper articles or public denials that Joseph made. When he shortly before he died, he said, I will prove all the people who have charged me with plurality of wives as perjurers. What a thing it is to be accused of having 7 wives when I can only find one. I mean, you have all kinds of stuff like that. You have Emma's denials. I mean, one of the usually a lot of the counters that people that are coming at this from a more of an academic mainstream perspective says is, well, you're calling a lot of these women liars. You're calling, Eliza Snow, you're calling Lucy Walker. Is Lucy Walker, Melissa Lott, and Emily Partridge that testified in the Temple case. You're calling them liars, but the counter that the polygamy skeptic will take is, well, you're calling Emma a liar. I mean, that's another woman that you're calling a liar.
Mm-hmm.
And so, I mean, you can start to see that, and to be fair to a lot of polygamy skeptics, I mean, we have lots and lots and lots of testimonials about the transfiguration of Brigham Young, and mainstream historians are more than happy to dismiss those all as later recollections and say that that's reflective. I mean, they are.
Mm-hmm.
There's a lot of things that they are. So there's a lot of these things that I think they bring up that are good questions that I think that they're sincere at, that they haven't really had answered. And so, I mean, that's part of what I'm trying to do with all of this too, is I want to say, yeah, I understand. At least I think I kind of understand where you're coming from. There are some answers to that. And so,
so just because something is late doesn't mean it's unreliable.
Right. And so, well,
it sure is convenient when it helps your case, though.
Yeah, it is. I mean, and in a lot of cases, a lot of the people that will make that argument don't have any problem considering like these later statements from Emma Smith or William Smith about what they think happened in Nauvoo. A lot of the folks doing this don't have any problem taking those statements at face value. But but I mean, it is an unusual situation because it's Nauvoo polygamy starts. Of course, polygamy possibly starts as early as 1831. There's the Fanny Alger incident in the mid 1830s. But when polygamy really starts is the time that we can most definitely say is it's April 1841, and it's not until 1852 that it's announced that anybody is speaking about it publicly. Yeah, in any kind of thing like that. So, and it's an unusual thing because some of the principal actors in the early part, Joseph and Hiram Smith, died long before or pretty early in that. And so, so part of that is I use this example in the paper. This is the paper I'm coming out that's going to include in this book. Is Alexander Hale Smith, who's Joseph Smith's son, makes this argument. He says, I would much rather take the words of Joseph and Hiram, and he's referring to, and he quotes a lot of things in the Times and Seasons that have been published in the Nauvoo newspaper, than I would over these old wives' tales we have heard of late. And so he says that too. He says, well, we have their words, and so that should carry more, that's contemporary, that's from them, that should carry more weight than these later recollections from these from the Utah Mormons. But then he also goes on about how he quotes at length many of the statements from like Parley Pratt or John Taylor denying that they were practicing polygamy when clearly they were, and when they later admitted that they had been all along. And so for him, it just is not possible that that's exactly what his father was doing as well. He says, no, Joseph and Hiram wouldn't do that. They went to, they braved prison, rather than deny the truth. Well, so did Parley Pratt. I mean, he went to prison when they did too, and was in prison for longer than they were. And he's one of these guys too. So, I mean, I can see why, especially as a religious apologetic, you could say, well, he's the prophet. We know that he tells the truth because he's the prophet. That may or may not be true. If he knows that he lied, then that means that he's not the prophet and has implications. Well, that may or may not be true. I think that's an important discussion, but it's irrelevant to whether or not it actually happened. We can talk about implications after we establish facts. And so he doesn't. So there's that. So so because this is an unusual situation.
Well, let me just throw in something here really quick.
Right. Okay.
Polygamy was obviously against the law. So
Yeah.
wouldn't it make sense for anybody who's breaking the law, whether they're robbing a bank or killing somebody or doing polygamy or adultery or whatever, to hide evidence? Wouldn't that be just human nature?
I think it would be, and I think there were much bigger things than the law going on too. I mean, you got to remember in Nauvoo, 1837, there's a massive internal apostasy, including many high levels of the church, that just escalates and causes more external problems, and they have to leave Kirtland. They have to leave behind the temple. 1837, the very next year, the same thing happens in Missouri. And they finally have a place that's really is the Saints' own. They have a chartered area, a city that they basically founded, and they want to build the temple. They want to have the church sustain, and they want to do missionary work and bring more people in. And that's really just not going to happen with polygamy. I think had Joseph been public about polygamy, then I think there would have been massive fallout. I don't think the temple would have ever gotten anywhere close to being finished. So that's I think that's part of why he did it in secret. So I mean, it's if it depends if you're looking at
so
Joseph,
it should be natural to expect secrecy.
Yeah, I think it should be. I mean, if you're looking at Joseph Smith from more of a sympathetic, from your more sincere perspective, you could look at it like he was using consequentialist morality. He thought that it was important that he implement this celestial marriage while also doing these other things, and that's how he decided to do it. We may disagree with the ethics of that, but it is understandable that he did it that way. And so, I mean, if you're looking at it, Nauvoo polygamy and Joseph Smith's polygamy is a messy topic. I mean, there's really no way to look at it in a way that's completely sanitizes all of it. You just, I mean, yeah, you look at it for what it is and such. And so I think that's it. I don't really know. It's an interesting question of what his game plan was. Was he planning on going public with it at some point? I mean, I don't really know. When Joseph Bates Noble he's the one that facilitates that first sealing of marriage to Louisa Beeman, and he says that Joseph told him, "Here, I'm putting my life in your hands. I'm asking you not to betray me to my enemies by asking you to do this." Was that going to be forever? I don't know. I mean, they certainly could have gone public with it a lot earlier than they did in Utah. I believe it's Lucy Walker who writes at one point that Joseph told her that he would be able to publicly acknowledge her as a wife after they had left Nauvoo and gone to the Rocky Mountains. I don't know if I don't know if we should consider that statement reliable. But I think part of what he did is he wanted to introduce it slowly into trusted people, and that by doing it that way, by introducing it to trusted people like the Quorum of the 12, like some of his close friends that weren't particularly, high in the hierarchy, like say Joseph Bates Noble, that by introducing it to them and having them doing it, he would make it would be easier for the church to accept it. And in a way, it worked. I mean, they were able to have a substantial number of people enter into plural marriage by the time they left Nauvoo, just a few years later. So in a way, that way did work, and it also stretched out the whatever fallout they had. I mean, of course, there was fallout. So if it's secret, yeah, the real question is what kind of evidence should you reasonably expect in a scenario like that?
If you knew it was secret.
If you know something is a secret, and so something where they're not admitting it, or the people involved are denying it openly, and in
And
many
polygamy
cases,
skeptics should at least acknowledge that, okay, if
I think so. I
this
think
did
so.
happen, it was secret.
If you're going to look at the contemporary evidence of Joseph Smith's polygamy and say that's deficient, I'm expecting more than that. You should compare that to the evidence for the other people that did it. So, of course, the person we most closely associate with the Joseph Smith's monogamy argument is Joseph Smith III, his son, who advocated it for many decades. He has a hard time settling on what exactly he thought his father was doing. At some point, he thought, well, he was just doing sealings that were not actually like husbands and wives in the full sense of the word. At another point, he says, well, Joseph facilitated sealings. He didn't know where it was going, and other people took it and made it polygamy. And he didn't find out about it until it was too late to do anything. He says that at another point. But really most consistently, this was the traditional RLDS argument, is that polygamy wasn't happening while Joseph Smith was alive. John Bennett sort of did his thing there, but I mean, in terms of polygamy happening within the leadership of the church, it wasn't happening while Joseph Smith was alive.
So not Joseph, not Brigham, not Hiram.
That's my understanding of it is really that's what it is.
I hope you enjoyed our conversation with attorney Mark Tensmeyer. In our next conversation, we're going to talk about the historical RLDS positions on Joseph Smith's polygamy. Did you know that current prophet president Stephen Vesey of the Community of Christ has admitted that Joseph Smith practiced polygamy? Is that an official statement?
It doesn't become their official position, and it still is not. What they'll say now is that they don't have official positions on historical issues.
Oh, really? Because I know President Stephen Vesey has talked about that.
Oh, yeah. As has, yeah.
And he's the current president.
Yeah. Oh, the church leadership will say it all the time. And yeah,
but that's not official? The president's not an official?
As did Grant McMurray.
Oh, wow.
If you'd like to hear the entire interview uncut, please subscribe to patreon.com/gospeltangents for just $5 a month. Patreon is spelled patreon.com/gospeltangents. If you'd like to watch the entire video, you can subscribe at YouTube, Patreon, or on my website at gospeltangents.com and click the yellow subscribe button for just $8 a month. PDF transcripts are just $10 a month, and you can get those on patreon.com/gospeltangents or on my website. I'll send those to you as soon as I've finished completing it. If you'd like to get a paperback and PDF, just subscribe for $20 a month at either Patreon or on my website. Individual paperbacks are available at Amazon.com. Just do a search for Gospel Tangents Interview, and you can find all of our past interviews there. Show your Gospel Tangents pride by purchasing a t-shirt on our website at gospeltangents.com/shop. Subscribe on Apple Podcasts at tinyurl.com/gospeltangents. You can get our latest updates by friending me at Facebook, or you can also follow our page at facebook.com/gospeltangents. Become an insider and you can see the newest videos. Follow us on Twitter at Gospel Tangents. Click here to subscribe, here for a transcript, and over here we've got some of our great videos. Thanks again.